Assalamualaikum and very good evening to all the lecturers and my fellow friends. I, Fahmi Bin Adilah, today going to present my research paper. The title of my research paper is Malaysian Anti-Money Laundering Law and their impact on private and public sector. First, the abstract. The Malaysian law place an obligation upon reporting institution to help prevent money laundering activities. It is a method where ill-gotten monies from illicit activities such as drug trafficking, corruption, illegal gambling, human trafficking, sexual activities, etc. are channeled through some legal vehicles so that dirty money is changed into legitimate money. The objective of this study are to analyze the current Malaysian law regarding money laundering, to identify advantages and disadvantages of the current anti-money laundering law, to analyze their impact on the public sector and the private sector, and to make recommendations on any improvement that should be made. This study will use a qualitative method where the literature review method applies to collect data and information regarding anti-money laundering laws. Data and information were collected from the various provisions of laws, text reading such as books, articles, journals, law cases, and theses regarding anti-money laundering laws, and those analyzed the content analysis method and critical analysis method. This study found that Malaysian anti-money laundering law have control over individual and corporate entities in Malaysia. For introduction, money laundering is a rising crime in this era. It has been alleged as a complex and highly intelligent crime and deemed as a deliberate act of manipulation carried out to fulfill a personal benefit. There is no reservation that money laundering seriously disturbs the integrity of the financial organizations. Money laundering activities pose serious risks to a nation's social and economic stability. While many guesstimates have been made, the illicit nature of money laundering makes it tough to regulate the exact total of funds that are laundered. According to Global Financial Integrity (GFI) report, our country, Malaysia, now stands at number 5 in the world with an illicit financial flow of $30.7 billion between 2009 until 2018. The Financial Action Task Force (FATF), as the leading intergovernmental body in the fight against money laundering, firmly states that it is absolutely impossible to produce a precise estimate of the amount of money being laundered due to the degree of complexity of its operation. Malaysia, in fulfilling its international obligation and commitment to establish FATF 40 recommendations, passed the anti-money laundering law, AMLA, in conformity with prevailing global aspirations, and in order to fortify steps against terrorists and other illegal money laundering activities, the Malaysian government introduced the AMLA. The Central Bank of Malaysia, Bank Negara Malaysia, has been appointed by the competent authority for the purpose of combating money laundering activities under the above act, which came into effect on 15 January 2002. The methodology used in this research, this paper adopted a qualitative method. Data collection through document analysis can provide relevant information to the issues and problems studied. Documents are the easiest source to the researcher because the required information is already available and difficult to deceive. The analysis will be made with points drawn from sources which relate to money laundering and relevant laws. Research for this paper will be undertaken using different sources. The study intends to analyze the current Malaysian laws and rules regarding money laundering, to identify advantages and disadvantages of the current anti-money laundering law, to analyze the impact on the public sector and the private sector, and to make recommendations on any improvement that should be made. For literature review, Sanusi et al. Stated that money laundering activities in Malaysia commonly exploit higher risk investments such as gold investment that promises higher returns. It could attract excessive numbers of people in search of fast and easy money. The progression of the money laundering cases charged under AMLA FA 2001, which involve a large amount of money, require a long period of investigation. However, there is no definite pattern of time taken to investigate and prosecute the cases. It depends on the availability of sufficient evidence. The length of time taken to investigate and prosecute a case refers to the time taken from the moment of the case was investigated to the time it was charged or sentenced. The length of the period taken in each case varies accordingly. According to Yahya 2014, The growth in international trade, interlinkages of the global financial system, and advancement in technology have presented both the risk and opportunity to the private sectors. From the business perspective, this development provides for greater access to the wider global market. From the money laundering perspective, this also means that criminals have greater means and tools to launder their illegal proceeds into a form which appears to be legal. Changes in the business and economic scene present a challenge to law enforcement agencies, financial regulators, and supervisors. To ensure that we are active in protecting the financial system and the broader economy from the threats of money laundering and terrorist financing, cooperation and collaboration is not a choice but a vital requirement. In this regard, there must be a solid working partnerships between all the law enforcement authorities, regulators, supervisors, and the private sectors. Without that, our efforts will be pointless. According to ALUCO 2011, one of the most serious microeconomic impacts of money laundering, particularly in many developing countries, is felt in the private sector. Money launderers often use front companies to fuse the proceeds of their illicit activities with legitimate funds to hide their illicit proceeds. Therefore, the front companies, in this instance, usually have a competitive advantage over legitimate companies or manufacturers that draw capital funds from financial markets. This makes it tough, if not impossible, for legitimate business to compete against front companies with subsidized funding. According to Vaitilingam and Nair 2007, money laundering and other financial-related crimes have significant economic and social impacts for worldwide countries. It deteriorates the financial system, which are the main player for global financial transactions. Eventually, this will endanger the socio-economic development of the countries involved. According to OMA 2021, December 1, mentioned that in this respect, it is observed that the public-private partnership, PPP, is gaining momentum and is fast becoming known as a key success factor for effective information sharing in the ML, CFT, CPF ecosystem. In Malaysia, the PPP is undertaken through the Financial Intelligence Network, MyFinet, which involves collaboration and information sharing between LEAs such as the Central Bank, Royal Mission Police, and Malaysian Anti-Corruption Commission, and private sectors such as financial institutions. With regards to finding and recommendations, the establishment of Amlat Fua has given a greater impact to society, including private and public sector. In order to respond to the evolving money laundering and terrorism financing threats and the international standards, Malaysia has established a comprehensive AML-CFT framework covering the legal and regulatory framework, preventive measures for reporting institutions, financial intelligence unit, and law enforcement agencies and domestic and international cooperation. Amlat Fua is the primary statute governing the AML-CFT regime in Malaysia. The Amlat Fua provides for the offense of money laundering and terrorism financing and the measures to be undertaken for the prevention of money laundering and terrorism financing offense. All reporting institutions, RI, are required by law to undertake preventive measures to prevent their institution from being used as a conduit for money laundering and terrorism financing activities. The preventive measures include conducting risk assessment, application of customer due diligence, submission of STR and CTR, maintenance and retention of records of transaction, implementation of ML-CFT compliance program that is reflective of the reporting institution money laundering and terrorism financing risk profile. The RI consists of various sectors such as banking, insurance, money services business, electric money, capital market, development financial institutions, other financial institutions, and designated non-financial businesses and professions. MyFinet is a public-private partnership PPP initiated by Bank Negara in 2017 and was officially launched by the Prime Minister of Malaysia in November 2019. MyFinet is led by the FIED, Financial Intelligence Enforcement Department, Bank Negara Malaysia, FIU, in a joint partnership between law enforcement agencies and financial institutions that are involved in combating money laundering, terrorism, and proliferation financing and other serious crimes. MyFinet operates a decentralized model where the relevant officers of the FIU, law enforcement agency, and financial institution work on specific cases from their respective office. Upon prior arrangement with the law enforcement agencies, relevant officers or FIU, law enforcement agencies, and financial institutions will convene for a meeting based on specific date and venue, where officers of the law enforcement agencies will share sensitive intelligence, including identified subjects and other specific topical issues. Among the recommendations that can be made, the government must continue its involvement in anti-money laundering matters on regional, multilateral, and international basis. A legal training should be formulated which would include knowledge regarding all laws, regulations, and rules of anti-money laundering. To create more awareness among public regarding money laundering matters, and if possible, the law should include non-reporting institutions, including the public, who have any information pertaining to any suspected activities relating to money laundering or terrorism financing obligation to lodge a report to authorities. The government is implementing policies to prevent money laundering and increase integrity among civil servants. One of them is the establishment of a unit of integrity in the public sector. Integrity unit shall be set up at all public sectors, and in this regard, the government will continue to take steps to strengthen its integrity by ensuring civil servants uphold the principles of integrity and accountability towards better public service. The government shall add more fund and invest to the relevant authorities in their preparation to wage war against money laundering. Criminals become more advanced, and with technologies, and authorities must be a step ahead from them. In conclusion, Malaysia has been through difficult times for the past few years due to major issues affecting its effort to fight corruption and money laundering. This difficult episode is not expected to be repeated in the future. Quoting the words of former Prime Minister of Malaysia, Dr. Fahmi Bin Muhamad, Malaysia should be known for its integrity and not for corruption. By that, in the face of the challenges of globalization and the political scenario of uncertainty, the government needs to set its direction through development of an integrated and comprehensive strategic effort to fight money laundering. Acknowledgement, the author would like to express his utmost gratitude to the Faculty of Law, Institute of Malaysia, for facilitating this project. Thank you.